Full compliment. Hey, Matt, thanks for joining us virtually. So everybody, thank you again for coming. My name's Scott Moskol. I co-chair our cannabis group with Frank, and this has been a journey since 2013. It's been a wild journey, but one that's been, I think, very satisfying on multiple levels, not just professionally, but personally. I was reminded over the last couple of days, unfortunately, so I have Crohn's, and I had a little flare-up, but what's reminded me is one of the reasons we did get into this industry is because of the medicinal benefits of this plant. And cannabis is, hopefully, we talk about rescheduling, but hopefully the DA comes quickly because there's so many medicinal qualities of cannabis that we just don't even know about yet. So this movement, this industry is not just about making profits, but it's also about making people's lives better. And I know a lot of people in the audience have either friends or family who suffer from Crohn's and other autoimmune diseases in which cannabis has a lot to play in terms of helping the benefit. So hopefully, in some small way, we're helping the entire ecosystem in that regard. So anyway, so now to the program. I guess you guys are the zombies, which may be better than being the munchkins. I'm not really sure. But today we're talking about distress in the cannabis industry and restructurings, and sort of following through with this theme that Frank brought up about ecosystem. What we have done for this first panel is brought an ecosystem of professionals who are involved in all sorts of different ways in a cannabis workout. So I'm just going to make a quick introduction of our panelists going from my left to, well, down there, and I guess right to left as I think about it. But first of all, we have Stuart Kim. Stuart Kim's, well, you have his bio here, but he's a founder of PGP and extraordinary investment banker. And he is here to talk about, from his perspective, being involved in various distressed M&A transactions, and frankly now with a receivership that some of our other panelists are involved with. So Stuart is going to represent the investment banking perspective. Next to Stuart, we have retired Judge Frank Bailey. Frank took the bench in 2009 and retired in 2022. And since his retirement, he joined Pioneer Public Policy Law Center, which is a nonprofit public interest law firm, as its inaugural president. And they work with committing underserved individuals with respect to education, equity, economic opportunity, open government, and provided that representation should lead to significant systemic change. And given the mission of the Pioneer Public Policy Law Center, in many ways is duplicative, not duplicative, but common to this industry in the sense of social equity. I think there's a lot of commonalities here and synergies. And so we thank retired Judge Bailey for being part of this and giving his unique insight into this emerging world of cannabis workouts. So far, bankruptcy has not been allowed or access road for cannabis companies, but who knows what the future will hold. And fortunately, since you are retired, I don't have to start off my speech by saying, what you say here on the dais, you can't use against you in a court of law. So anyways.
Don't want to hear it again.
Yes, you can say whatever you want for once, right?
That's right, whatever I want.
Next to Judge Bailey is Kyle Judge. Kyle is from Hub. Yeah, he is a D&O guru in of itself, but certainly in the cannabis industry, no other person has his depth and experience and understanding of the D&O insurance policy world and coverage world. And this becomes more and more important in the, sadly, in the insolvency space, given that so many of our companies that may be going out of business, one of their only assets could be the D&O policy. So that comes into play often enough. Next to Kyle, we have Jacques Santucci. Jacques has been with us many, many times. He's with Opus Consulting. and he was our receiver in the Irmont case, which Frank referenced earlier. Also right now, he's serving as receiver in another case called The Source out in Nevada that we're involved with, which actually Stuart is involved as the investment banker, and next to Jacques, Tom Lynch, his partner Tim Bosley is involved as CRO. So Jacques is here, although he has served in other capacities. He's here to kind of tell us from his perspective as a receiver. Next to Jacques, I kind of spoiled the surprise, but we have Tom Lynch. Tom is with Emerald Peak Advisors, which is an off-growth of Sierra Constellation, which is one of the preeminent turnaround boutiques in the country, I would say. And they turned that turnaround experience and turned it to the cannabis industry, and they've been involved with some of the largest turnarounds and restructurings in this industry. You know, MedMen and Ianthus in of itself is certainly sufficient as a, as a hallmark of what they've done. And then last and certainly not least is our friend Matt Hawkins, or Hawk. Matt is one of the founders of Entourage Effect Capital, and Matt serves in multiple capacities on this panel, part of our ecosystem. Not only has Matt obviously been an investor, whether as investing via debt or equity or a combination thereof through Entourage, but Matt has served in his capacity, he served as a board member of State House, and actually is chair of the board still to this day. And so, and to a certain extent, when we keep talking about restructurings and workouts, understanding where the board comes into play and the fiduciary duties and perhaps even the fears of a board member when this happens. We're very excited to have Matt be involved with our panel today. So we have a great panel, so let's just jump in. And I think, we've spent enough time, there's been enough conferences, why is the industry here? 280E, bad economics, oversupply, the legacy market. But, and so we know, easily enough, we know why we're here. The question is, what can we do about it? And so I'm going to throw a bunch of questions out to the panel. I'm going to start with one of the panelists, but hopefully the entire panel should just feel free to join the conversation. This is a conversation, not a Q&A. So Tom, let's just start with you. And the question I have for you is, if there's a struggling company out there and you're brought in, whether it's an FA, CRO type, whatever the title could be, what do you look at first in terms of how to turn this company around? And what strategies are there, like real strategies are there, given that, cannabis is federally illegal? And I guess, with respect to that, do your strategies change if the company's vertically integrated versus a branding company versus a retail? Because oftentimes we treat the industry as ubiquitous, but it really isn't.
Okay, so I'll end with the strategies piece, but from the perspective of an operator, it depends on why we're there in the first place, right? So if a company's struggling and they've had the foresight to reach out to us, that's one thing. That's rare, frankly. If it's an investor in the company or a lender to the company that's called us, that's more likely the reason that we're there. And we can go into a couple of the reasons why those typically happen. There are some thematic things that run through every case we've been on that are pretty predictable. We know what's not available to us as far as we call it restructuring, but in the way that we've all traditionally defined that, it doesn't exist, right? We all know that. I'm not going to waste time on that. But when we go in, typically, if a lender has placed us in there could be, regardless of the deterioration of the industry broadly, there could be a specific reason unique to that company that the lender and the company have kind of lost that connection that they had, right? So it could be the reporting, it could be administrative covenants within the loan documents that have been missed. There have been things like that. So boring, don't want to spend a lot of time on that. What can you do? If you're sitting here right now and you're getting the sky is falling message all the time, what can you do? So the first thing I look at as an operator, and I came from operating big retail companies for a long time, is looking at the cost side of the equation, of course. Any leverage in the earnings is going to come from the G&A part of the SG&A. It just is. I have seen bloat, as everyone in this room knows, the likes of which I had never seen, going on 34 years in business, the likes of which I have never seen before. I had one company, the first one I got involved with, we took $160 million out of corporate SG&A, and there was still more work to be done. So get that part of the equation right. Really take a good look internally as to where that is. It's bloated everywhere. If you have a retail operation, measure everything. Get your assortment right. This is really, it's going to sound very basic, but get your assortment right. It's one thing to be able to take such pride in the ability to cultivate and grow and have the test results that blow everyone away. The consumer doesn't care. The consumer doesn't care, and it's just something that we can tell in a kind of a circular group. So focus on that. Lean into the consumer. Let the consumer tell you what it is they're looking for. There are opportunities within the unit economics of the existing stores. Right now, I get very frustrated when I go and people just talk about, oh, if I could only grow, if I could only grow, if I could only grow. Well, growth, in a lot of ways, is what's got us here, right? We've expanded too much. Take a look at the actual individual boxes, the profitability of those. Laser focus there. Measure everything, absolutely everything. And it starts with the assortment, and that goes arm in arm with the consumer experience. So I don't know if that helps at all.
Yeah, no, but what you just described is sort of turnaround 101, right? I mean, is there anything...
That's where we are.
Well, that's the point, right? I mean,
Right.
In many ways, cannabis shouldn't be treated like any other... It's just another business with a retail, agricultural
the challenges that are unique to cannabis come on the regulatory side and the things that we all know. And if we're just going to keep tilting at windmills thinking that any one of us is going to fix that, we're going to continue to waste time. The fundamental operating entities, the businesses themselves, are no different. They're just no different. So if you've got product that you've fallen in love with, that's no difference than the Gap falling in love with an assortment for the spring and firing their customer, or Victoria's Secret firing their customer because they just went down a merchandising path that blew the company up, right? So it's blunt, but it's more, okay, what is the consumer looking for? Are we overwhelming the consumer because we know so much and the industry's so nascent that we missed a few steps? Yep, for sure. So I would start there. And that's no different than retail restructuring and a lot of traditional business.
Which has been a thesis that I think a lot of people in this panel have had. Jacques, did you want to?
No, I agree. I agree with Tom. I was a past operator, and each time I go to one of those stores, I see the number of SKUs that are in the retail store, and I have no idea, even after 13 years in this industry, sometimes I don't even know what the product is. So to your point, right. I'm sure half the customers, they have no idea. And so we're trying to push brands and SKUs and kind of to please the other partners in the industry. And at the end, I think we're missing an opportunity. And the other part is to do that, you need data. And to what you're saying, I agree 200%. Most of the time when I get in, there's not enough data. I mean, at least, lately the bookkeeping has been done correctly, but you mentioned Airmont, there was major errors in the accounting, and then, you don't even have the data on what sells, what doesn't sell, and I'm not even talking about cost of goods. A lot of companies, they have no idea how much it costs them to produce whatever they're trying to sell.
But, one difference in the cannabis industry seems to me, and maybe this is something others in the panel can talk to. I mean, when we do turnarounds, there are other sources of liquidity, right? Because a company, insolvent companies need money to survive and push forward to the turnaround, right? I mean, what are you guys seeing in terms of liquidity in the cannabis market, in terms of bridge financing, or even the equivalent of like a DIP loan for a receivership type concept? I've seen very little. I'm just like Stuart, your investment banker. I don't know if you're seeing any openings yet for sort of more turnaround traditional liquidity sources, even bridge financing to like a sale of some sort.
Well, I think a fundamental rule of restructuring is that in order for new capital to come in or strategic solution to come in, there has to be positive enterprise value on top of liquidation value. And I think it's very difficult to underwrite a lot of companies in today's environment that have been cash flow negative for a long time. And the larger problem as far as capital coming to the industry is, the new capital is not coming in for reasons everyone here knows. And the existing investors in the industry are very skittish about coming in and serving that role, and because they've got their own problems and they want to husband their capital in case the situation gets worse on those. So we're stuck between a rock and a hard place where a number of these turnaround situations should be interesting, should be a great opportunity to come in. But we have lots of discussions, like many of you in the audience, with new sources of capital. And what's really frustrating is we leave some of these meetings with huge family offices with very aggressive entrepreneurial types of investors, and we walk out of the meeting and they slap us on the back and they say, wow, great thesis, now's the time to come in, and we agree with your points A, B, and C as far as the situations. Then they make 2 phone calls after the discussion. They talk to another family office that's been in cannabis for 5 to 7 years, and they say, whoa, we got our face ripped off, you can't go into cannabis. And then the second thing they do is they then do a Google search on cannabis path to legalization and all the complexities there, and then it's difficult to overcome those things. But I think in certain situations we're having some luck, but the straight bridge financing into a company that's losing money and it's upside down cap structure wise, it's very hard.
Judge Bale, did you want to?
I did. Can I be heard? Yeah. Oh, good. See, this, folks, is a tie. I now know why they exist, because you can hang the microphone on it very nicely and it works well. Anyway, you'll know who is the oldest guy up here.
Hey.
I want to first thank Burns and Levinson and Max Board for inviting me to be here today. It's an incredibly important topic and a hot issue, on our bankruptcy bench around the country. So when I hear, investment bankers talk about, dip financing, and I realize that Section 364 of the Bankruptcy Code gives the judge tremendous power to give dip debtor in possession financing protections that they can't get really in any other context. Maybe the receivership statute will help, but there's nothing better than having the supremacy clause on your side, and you're working through the federal bankruptcy system. I know we'll get more into, why bankruptcy is not currently available. Tom, I don't agree tilting at windmills. I hear those words. Mm-hmm. It does seem that way. I'm here to tell you that there are some recent cases where judges are looking at this in a more nuanced fashion, in a way that perhaps even without regulatory change, there is hope. Here's the big deal in my mind. Most of restructuring takes place outside of the bankruptcy courts, but within the bankruptcy, in the shadow of the bankruptcy code. So if Scott is representing a debtor, or even a creditor, really, excuse me, and he can talk to the creditor body about, I haven't filed them, but y'all know I could, and then I'd get first day orders, including dip protections. You might as well make the deal, because once I put them in, you're going to have a lot of people come out of the woodwork. You're going to get the U.S. trustee involved. There could be some expense and some administrative costs up front. So not having the bankruptcy code or not having the bankruptcy system as an option is doing tremendous violence to the industry, in my opinion. And I am here to tell you, and I'll talk more about this perhaps in a little bit, but that I do see some light. The Hacienda case is what I have in mind, Scott, but which Scott sent me, and the last thing I'll say is I had a lot of, I saw shakeouts in my 14 years, in the microbrew industry, very common. I was around during 2020 when a lot of operators in food service and et cetera. The most Relevant, though, to me is the microbrew industry because it grew in the same way. And to me, there's no distinction. There just isn't between this industry and that one, except for, legacy, hypocrisy. I don't know how else to say it. But anyway, so we need to be able to give investment bankers, other dip financing entities, an opportunity to be protected in a way that they feel comfortable in investing in these companies so that they can do a turnaround.
So I think, all the cannabis industry, we've never wanted anything special, sort of special treatment. We just want to be treated like every other industry, every other business, because regardless of the federal illegality, it's legal in 38 states and producing, $30 billion in revenue annually. So let's just go back to the financing. Unfortunately, we have Matt Hawkins, who is a part of Entourage, who do invest in these cannabis companies. And I guess my question to start off with, Matt, is, when you're looking at companies and you're doing sort of your underwriting, they're coming to you, what are some red flags from your perspective? You're wearing your investor hat, and whether they're asking for a debt infusion, convertible notes, equity, what are red flags that you have seen over and over again that this company that's looking for funding just is not likely going to make it?
First of all, thanks for having me. Sorry I'm not there in person. It's no different. I mean, that question could be asked of me whether we're in boom times or in down times, because at the end of the day, from an equity perspective, we're underwriting management teams and we're underwriting, business plans in what we think to be scalable markets. So that hasn't changed. I think what's changed now that we're in the environment we're in is that, we're one of the few capital providers in the industry, and we don't have unlimited capital. So to Stuart's point earlier, most of our work, especially with our legacy funds, is using the capital that we've set aside for follow-on investing to make sure our companies survive. And the structures, around those types of investments are almost 100%, convertible debt with warrant type instruments. And that, we want to, not be crazy greedy on the coupon and crazy greedy on the terms, but also be able to benefit in what we think are very depressed valuations currently. So if they can, use this as a lifeline to get to the other side, then obviously we're going to benefit from a return standpoint. With new investments, it's very, very difficult. We're hopefully going to be launching on a decent amount of capital by the first of the year, and with that, we will start to look at larger new deals, but in the same structure I just described is what we're doing with existing companies. So we can talk more about that, but I think that's probably a good place to stop.
Yeah. But when, let's take your existing investments, and I know, unfortunately, because we've worked with you, there are a few that have gone off the reservation, let's just say, or off kilter.
Hey, what are you talking about? I mean, what attorney-client privilege here? What's going on?
No. But it's a badge of honor. I mean, I don't know. But what do you do? Like you're the office. You're talking to everyone. All of a sudden, you get news. Oh, they're going to default, or the world's coming to an end. From your perspective as the investor, what's your first course of action? What are your first strategies?
Well, luckily, we have a solid enough team, and our asset management group is very tuned in with our portfolio, and so we know well in advance what's going on and what's going to happen. So there can be a lot of planning in advance of some type of doomsday. I mean, there's several companies that come to mind right now in our second fund that we've been working with for years, months, if not years, on the next vehicle that comes in and how it's structured. So very rarely are we just 100% surprised that a company we thought was doing well all of a sudden is going to run out of money in 2 weeks. I mean, that I can probably count on one hand how many times that's happened, and that was, special circumstance. So I'm grateful that our team is solid enough that we track the investments pretty closely.
I think, one of the things I know that you, or not you personally, but Entourage will do in certain circumstances is to provide some type of bridge financing. What goes into those considerations? I mean, fortunately, I think Entourage is made up of a bunch of folks who came out of the workout world and special situation funds and understand how bridge financing can preserve value. But what goes behind those strategies or those deliberations?
It's pretty simple. And we were talking about, workout and restructuring 101. I mean, at the end of the day, a bridge loan is a bridge to something. And so the first thing we're going to underwrite is what is that? What are we bridging to? Is it outside capital with terms that we like? Well, that's great. That's an easy answer. If we're bridging to an event that is uncertain, then that's a whole other conversation, and that needs to be priced accordingly. So it's a delicate balancing act because, you're right. A lot of us come from the restructuring world, and you have to wear a lot of hats when you're the fiduciary of the capital that you placed, and so that can be tricky. But we've been talking about how there is no new capital coming, so a lot of the times these bridge notes are sometimes bridges to getting the rest of the cap stack to participate in the next round, because there is no new equity or for the most part new debt coming in. The debt was probably already in place with real estate that is the collateral, but other than that, there isn't anything.
Do you think that if bankruptcy were available, I know you and your team have done more than your share of 363s in your lifetime, do you think you would be, or Entourage would be more apt to provide some level of DIP financing, or does it not really make a difference? I mean, I know you're going to say it depends. You're going to say lawyer answer, it depends, but.
No, I think if we had, as debt investors, if we had the luxury of bankruptcy protection, that'd be awesome. But on the other hand, a lot of our investments are equity, so we need to be careful what we ask for, right? So, but yeah, I think DIP financing would be not only something that would be attractive to us just being in the industry, but it'd be something for us to be attractive to provide ourselves.
Sure. So as an alternate DIP financing to the industry, if and when, I shouldn't say if, but when bankruptcy is available. So let's jump a little bit. Kyle, you were here last year talking about how important D&O can be, especially during turbulent times, whether cannabis, non-cannabis, whatnot. And so in the last year, what trends have you been seeing with respect to claims being brought against cannabis companies who have some financial difficulties, and whether they're public institutions or private companies?
I think the trend certainly is your decisions as directors and officers are under a microscope even more than usual in this environment. From a private and public company side, we're seeing a lot more, pushback from lenders, creditors. We've seen some claims coming in from competitors with some of our clients on the private side. And these are all, fundamental areas that D&O, you can transfer that risk to. But, and I spoke about it last year, and it's in this environment, I think there's a tendency to try to get the least expensive option for your D&O to check a box. And a concerning trend with those least expensive options is that they're riddled with exclusions that can really leave you open to additional scrutiny, can leave you open to claims being denied. So I think the trends that we're seeing, as a risk manager and as a risk transfer broker, my conversations with clients tend to really be focused on, take a look at your policy and take a look at that coverage, because in this environment, we really don't see that trend stopping, and you're really under a microscope. So you want to make sure that you have, the right coverage in place, that you're spending this money on a policy that's going to actually pay for claims.
So what kind of exclusions in particular should the board or the board's counsel be looking at, or the officers as well, in terms of what could pose trouble if a claim is actually made?
Yeah, I mean, on the farthest end of terrible, there's I've literally seen directors and officers' policies that have a cannabis exclusion on there. So obviously that's a worthless piece of paper.
Explain what that is, because I've seen that in policies of clients. I'm like,
yeah, not to get too into the weeds, but it really is based upon the language that kind of is the preamble to that exclusion. Anything based upon arising out of or any way related to substances that are part of the Federal Controlled Substance Act, right? And cannabis being on that. I've never seen a carrier deny a claim on that, but just reading that, it's very broad, it's very concerning. If I was a director or an officer and I saw that on my policy and I was a cannabis operations, I would be extremely concerned that my policy was worthless. Other than that, we see a tendency to have creditor insolvency exclusions on there. Again, it's very similar language where it's written so broadly that anything arising out of that, right? It might not be an actual claim for that insolvency, but any claim arising out of it could be excluded. So again, trying not to get into the weeds, it's really about just how broadly those exclusionary languages are written on that policy and how restrictive it's going to be at the time of the claim.
And I can say, so I know you made this point last year, since that conference, I've had 2 non-cannabis workouts where looking at the D&O policy representing the company, they had a broad exclusion for any claims brought by a creditor. And when you're in an insolvency situation, pretty much every claim is a creditor claim, whether it's contingent or non-contingent,
right.
Liquidated, non-liquidated. So basically the policy was worthless because they were definitely in the zone of insolvency. And so we got a Side A DIC policy to cover the director separately, a lot from your tutelage. So
yeah.
I thank you, because this is really going to be important regardless of what industry we come from. Yes.
So this again, the bankruptcy code is so fundamentally important on issues like this one, right? Because that would be, I know I would hear an argument from Scott that if his client were to make a claim, it were to be excluded because of it excludes creditors.
Yep.
That would be what we call an ipso facto clause. I know he'd make that argument, and he'd win. So therefore, we would blow right by that exclusion. That's unenforceable.
But the exclusion doesn't say because they filed for bankruptcy.
It doesn't have to, though. It doesn't have to, though. That concept is broader than, it doesn't have to say if you file for federal bankruptcy protection. So the argument would be made, I know that.
Good.
And what would that do? So you don't file, and he goes to you guys and says, if I file, I'll have a reasonable shot at that. Maybe there is coverage.
Although maybe, is that collusion or on the IVI, but we're getting to coverage into the weeds, so.
Yeah, and I mean,
other than this table to hug people, I don't think anyone else is following us, but any new products out there for the cannabis industry?
I don't think it's really new products. I think it's a lot of our clients just expanding into existing products that they might not have been spending the capital on before. Employment practices tends to be a growing concern for a lot of our clients, right? Any kind of employee-related claims as they're continuing to grow and expand. Or on the opposite side, they're shrinking, laying people off. You're seeing an increase in those types of allegations. Cyber continues to be another big area that we're seeing a lot of our cannabis clients take a deeper dive into as they're becoming more sophisticated organizations. Cyber is obviously a forefront of a lot of claims in the industry these years. So no really new products. It's more just as they're becoming more sophisticated, growing their operations, getting more of the standard suite of kind of coverage and protection that you would see for organizations of those sizes.
And so going to the board side, and Hawk, when you're on a board, and fortunately, hopefully, State House, which you're presently on the board, is not going through these issues. But if you're on a board and there are some insolvency and restructuring issues, what are your immediate concerns, I guess? And then I'll ask the same question to Tom and Jacques, who often advise boards in their capacity as FAs.
So, yeah, luckily we haven't
Right.
crossed that bridge, and I don't hope
Nor shall
to,
you.
but
Nor shall you.
yeah, but yeah, I mean, there's a lot of things that we still have. There's a lot of restructuring groups that are more than capable of, jumping in at a moment's notice and an engagement to help in a situation like that. And I think State House would be no different than any other public company in that it would be something that would be an absolute, requirement to get outside help to try to fix the issue. Being a public company, there's a whole host of other issues you need to worry about. I mean, where your fiduciary responsibilities lie. And us, a little bit tricky because we're also large shareholders, but we have fiduciaries there as our investors, we're fiduciaries to them. So in a situation like that would become very, very tricky. And in some situations, I can even envision some type of a moment where a recusal might be necessary if it gets that tricky. But nevertheless, it hadn't happened yet. I hope it doesn't. And the other private companies that I'm on the boards of hasn't happened yet either. There was one time where we did engage an outside restructuring group to help us with a literally a complete turnaround restructuring that we ended up folding into the State House merger. But that was a full-on, strip everything down to the core and see what's there and, try to regenerate the assets of the company and start anew. And luckily we were able to do that.
And so Tom and Jacques, just looking at your careers as, whether it's in the industry or not, but like, what would you warn your board if they're coming into an insolvency situation?
First thing, so what was just said is spot on. I've served on more boards than I've just simply advised, and typically in the capacity of a special committee. So when something like that is put together, you designate a special committee. I've seen special committees of one. I'm on one massive one right now that it's a committee of 3, and all of the decisions, documentation of processes, all the things that you absolutely have to do, in line with the risk management, become the responsibility of the special committee and council. So that's what I would recommend, because the scrutiny around every single decision, once you reach that zone, it. And the documentation of everything from a capital raising process to decisions to terminate employees and how you go about doing that, and WARN Act exposure and things like that can be well handled by a special committee and professionals.
Jacques, did you want to comment? Or?
Yeah, no, I don't have much. I mean, I think they covered it.
So what I find interesting from my perspective as a lawyer, when a board's in this instance, all the board members ask whether they have personal liability for like unpaid payroll. So I would have thought that would have been the first thing going through all your minds, but.
Well, WARN Act liability, right? There's a zone, you've got a certain amount of days where you've got to meet your obligations to the employees, and if you don't, that can become a personal liability. There's a list of things like that. That one always jumps to the front because you're reducing costs. You have to be very smart and deliberate about how you do it.
I think that's the special committee, right? They're going down the list of risks, and employment taxes, unpaid. Okay, that's number one. That you got a big risk, but there's other risks that you got to start listing and looking into.
That's right.
And so let's jump to the sort of distressed M&A component of this panel. And Stuart, looking at you, what is the market like these days in terms of the cannabis M&A market? Is it truly more distressed? Are there any good deals out there? And then, with respect to your distressed or bad deals, how do you approach it differently than a good deal?
Well, let me address this maybe in a different way because there are a lot of companies now, maybe not on death's door, but facing severe challenges. And what we've seen is whether it's the management team, creditors, equity holders, oftentimes, there's obviously, given the negative environment across the board, I'd say it's more often than not, people are taking too long to swallow the medicine that they need to. And what happens, we've seen happen in this industry, we represented one of the creditors at Herbal, and saw the whole thing unwind and devolve, is because of the difficult operating environment, the deterioration of value in cannabis companies really accelerates near the end. So I would urge anyone in those categories, operators, creditors, and equity holders, to make decisions earlier when the patient is still can still survive, because what we saw was within a matter of 2 weeks the situation being salvageable to non-salvageable. I think the broader comment that I'd make is that underlying the challenges of the market, there's a certain degree of dysfunctionality in as far as how deals are done in cannabis, some of which relates to how capital accumulated, the rapid growth, and how easy it was to raise capital. But today, I think there's a mistrust between capital providers and strategic acquirers and their counterparties, because oftentimes the information going both ways isn't pristine, or the type of information that you can make a dependable decision on. In most industries, there are capital providers, such as private equity firms, that state emphatically, when we issue an LOI, we close 99% of the time if that LOI is accepted on those terms. What I've seen, and we're relatively newer to the space, is the LOI is just the start of a discussion, and that element. And then, by the way, intermediaries in this industry, a lot of them aren't doing their job. On Herbal, for example, we got, representing a potential solution provider, we got a model where, 24 months out, the company would still be losing a run rate of over $20 million. And we went to the banker and said, "Can you explain this?" And the banker literally said to us, "Oh, I don't know, I just passed it along. Our client produced that."
There's no independent.
That's not. You're an advisor to companies. We're advisors to companies. They need help in making sure what goes out the door to potential solution providers, to potential partners, is defensible, makes sense, because it really not only saves time, but it creates a trust in the deal execution process. That's really important, particularly given all the skittishness and nervousness about what's going on in the world and in the capital markets.
So, I know you're involved in the source receivership. You've been retained by the receiver, who's down over there, to sell the company or the assets of the company. And my question to you is, in that capacity, anything surprising to you about the receivership process compared to regular non-judicial process, or any additional hurdles you found?
Well, it's a completely different dynamic, because with the receiver in place who can lay down the law as far as what needs to get done by when, it's a very different dynamic than having a management team, the board, and investors, all of whom have different viewpoints on what is what they'll approve, what they want to have happen. It's just it's a lot cleaner. Actually, Scott, I don't like you mentioning the source in this context, because this panel is about distress, and the source is an amazing cash flow positive company. So let's not lump them together.
No. That's actually true, and certainly the receivership is due to multiple issues, but financial just a small component of it.
Correct. It's much cleaner situation as far as the cap structure that New Capital, the way they look at it, and from a decision-making standpoint, it's easier as well.
So, Jacques, you've served as a receiver in a couple of different recent proceedings. What were some of the unexpected challenges? I mean, you've been a turnaround advisor, both non-cannabis and cannabis for 25 plus years. What is your role as a receiver for a cannabis operation? What were some unexpected challenges you encountered, if any?
Yeah, I think the unexpected challenge is because under the court, in the court proceeding, our role is actually just to keep the assets where they are and not grow the company. And we're there to quickly find a solution within the within the receivership order that doesn't have all the protection that you were mentioning earlier. In other situations where Tom and I may have been into, we were there to grow the company and find a solution for very long term. In this case, and I'm talking to the people at the source right now almost every week, we're not there for a long-term solution. We're here for a short-term solution to keep the assets where they are and find a solution so somebody else can come and then get the long-term solution. That is very difficult because we're all into growing the company and we want to make big changes, but at the end, that's not why we are there. And we are, almost looking back and very, a few months ahead, not 2 years ahead, right? The strategy is very short term.
Tom, I don't know if you seem to be nodding your head.
I completely agree with that. I think thematically that's consistent with how the whole discussion started. I mean, that's spot on. It's the next month, 2 months in front of your face. We don't have that luxury right now, and it's frustrating for all of us, right? That's human nature. We want to grow.
I have the conversation with your colleague Tim every week because he and I, we're on the same ideas, right? We want to look at data and make changes, but unfortunately, it's not what we are there for.
That's right. As an industry, we've just got to make it. The most important thing I saw in the video that preceded this was the comment right before, it was the ETF analyst right before McConaughey said all right. And he was talking about, the Holy Grail, it's the CPG companies arriving. And when that inevitably happens, and it will, we've got to make it as an industry easy for them. Because what they don't want to do is come in and invest in a mess and have to do cleanup and turnaround and all of that, waste their time and money and energy on that. And so head down focus right now for me and for our clients is doing that. So what does that mean? It's integrity of financials, all the things that I talked about at my opening comments. I think that's very consistent with what Jock just said. It's a shorter term view, just getting it right.
How useful is, where the industry is now, how useful is the receivership tool, do you think? And is it a panacea?
So I'm not sure if it's the panacea, but it's very useful. We all know there's a lot of leases that were signed 5-7 years ago that should have never been signed, some contract that should never happen. I think the receivership has helped us for the past couple of years kind of clean up those companies, so at least whoever is coming next has a better started.
Very valuable tool. Not the panacea, but a very valuable tool. Very valuable tool. Frankly, one of the best available to us right now.
I think the myth though is it's not a cheap tool.
No.
I got a lot of phone calls. Oh, my company's not doing good. I want to file for receivership. This is not how it happens. It's an expensive tool to clean up 5 or 6 years of bad decisions.
So, this is a nice segue to Judge Bailey. But before we get to Judge Bailey, I guess the question I have for anyone on the panel is, it seems to me one of the huge differences, receivership is usually only for a liquidation proceeding, in the sense of sale of the company, whether it's going concern and pieces of assets, whatever. And fortunately, some of, for instance, Ermont, we were able to sell the entire company as a going concern. That's, I know what you're trying to do in the source, that you will do in the source, Stuart. But what about a true restructuring? And I have never seen it, but I'm wondering if anyone on the panel has seen state court receivership be used as sort of a way to restructure your debt obligations.
Not yet.
Not yet.
No, I haven't either.
It'll have to come.
Well, but that's a nice segue to bankruptcy, because in a bankruptcy, you can use the code to restructure debt obligations. There's restrictions, obviously. But Judge Bailey, why can't we have bankruptcy? Why can't cannabis companies, and we've all been told, well, you just can't go because it's federally legal, but is that the end of it?
Well, the case law, the precise reason is in terms of restructuring, so we're talking about a Chapter 11 process, is that I hate to throw sections around, but I have to. Section 1112 is the field, hold on. This is very bad timing. Okay. Okay. The field of battle is in this section 1112, which so the U.S. trustee is who is the watchdog. Think of him as the U.S. attorney in the bankruptcy process. Will file a motion to dismiss a cannabis case. And heretofore, it's been so broad, that if there's anything that touches and concerns cannabis within the case, whether or not they're still operating a business that's selling, marketing, if there's leases, it's been viewed so broadly. UST comes in and files a motion to dismiss. It's a more nuanced decision process, though. That section says that the judge shall dismiss a case in the event that there exists cause, and it doesn't enumerate this, but one of the causes would be the business is operating an illegal business, right? Now, the statute goes on to say, though, recognizing that even if there's cause, we need to build flexibility into the system, because sometimes, even if there's cause, there's reasons to keep this entity in the bankruptcy process because it's going to benefit creditors. It may benefit equity. It may benefit, for God's sakes, it may benefit the government to collect taxes, right?
Not that.
Yeah. And so this section goes on to say, you shall dismiss the case unless if there are unusual circumstances that demonstrate to the judge that there's a likelihood of successful reorganization. We have now seen in mostly cases coming out of the Ninth Circuit, which is California and West Coast, we have seen judges who are really struggling with that language and have concluded that there are unusual circumstances that sort of trump the illegality. We're not seeing those cases so much anywhere else yet. So the answer, though, Scott, is it boils down to that section, the dismissal section of the code. And for Chapter 13s, which is an individual, and I had those cases in the cannabis area, it's also for cause, and you read in the same language. And the U.S. trustee is dogged about filing motions to dismiss those cases. Footnote, when I started on the bench, you remember the Defense of Marriage Act? Very similar situation, right? Because under the Defense of Marriage Act, the single-sex marriages were federally unlawful. Supreme Court took care of that eventually, but in Massachusetts, remember, single-sex marriage was permissible. So I would have debtors file, single-sex couples would file as joint debtors, which is very beneficial to them, and UST would come in and file a motion to dismiss and say, Defense of Marriage Act, you can't have that federally. You're a federal judge. I found my way clear to keep them in, relying on state law. The First Circuit slapped me and reversed me on that, and then the Obama administration came in and changed everything. So, but they just said, we're not moving anymore, right? Instructed the Attorney General of the United States, don't make those motions anymore. That could happen too, right?
Right.
So, enforcement-wise, yeah.
I mean, technically at one point we had the Cole memo, which said,
that's right.
Basically, as long as you fall within, you're not violating any of those 8 priorities, the federal government won't spend any money going after compliant cannabis operators. I mean, Garland has basically said, even though we don't have a Cole memo, it's basically our principle, we're not going to waste money.
Yeah.
Why is Justice, well, the U.S. trustee program, which is part of Justice, still pursuing these actions? Or is it just hasn't filtered down?
Well, we have the memo from the UST himself, that hasn't been withdrawn, to my knowledge, that says, we're convinced that we have to make these motions and we will continue to make them. So, I think that Attorney General Garland has been busy. So,
just a tad.
Yeah. So I think that it just maybe hasn't risen to the level.
So in the industry, we have 2 new potential avenues of hope, right? So there's the potential passage of the Safer Bank Bill, which made out of the Senate committee, which would give a safe harbor for banks and credit unions who are federally chartered, state chartered, to both provide banking services, but also provide lending services, many of which do, many of our guests here in the audience do, but also rescheduling from a 1 to a 3, thus, provides it's a less problematic drug. Certainly opiates are Schedule 3, and there have been bankruptcies around opiates, Purdue Pharma. My thesis, granted I haven't had the ability to argue it, but if either of those, but hopefully if both are passed, that should allow a judge some extra push from the feds, whether it's Congress or the executive branch, to legitimize cannabis sufficiently for bankruptcy. So fortunately, you're not a judge. So, but if you were a judge, which you aren't, how would you, what do you think about those arguments? And do you think there is a path for a cannabis bankruptcy short of full decriminalization, full legalization?
Yeah. So you didn't mention the so-called States Act, right? I mean, that I think Elizabeth Warren proposed.
She's tried that one.
Yeah. So that to me, which would say that the federal judge can look and be, it kind of turns the supremacy clause on its head, right?
Sure.
Which, whether that would work at the Supreme Court, who knows? But what they're saying is, if it's legal in your state, then the judge can entertain the case. You don't have to. That to me is the panacea, so to speak, in bankruptcy.
Sure. But
that
we haven't
would
even gotten
work.
there with.
I know we haven't gotten there, but that working our way down the list, I'm not certain rescheduling would do it because it's still a controlled substance, right? And I guess I'm not certain about that. It would certainly give the judge more discretion within Section 1112, when that cause issue comes up, I think. So you might see some judges willing to go out. And what you need is a circuit court somewhere.
Sure.
It'd be nice if it was us first.
But we have to start with a bankruptcy.
No, it has to come up. It's got to bubble up. That's
What
for
about
sure.
what about the Safer Bank Act, which doesn't have that sort of same recognition of states' rights, but certainly saying, hey, federally chartered banks, you can go lend if this were to be passed.
It would protect them certainly in federal court.
Right. So why couldn't they have access to the protection? I mean, there are benefits to lenders, right?
But it doesn't. I don't see it as benefiting the debtor, and that's what you're worried about, right?
Well, it might, because there are instances where the lenders in a traditional insolvency situation want the debtor to basically file for bankruptcy.
Oh, absolutely.
363.
They drive it.
Because a 363 is so much more efficient than a state court receivership.
No, there are good reasons for it. I'm
Okay.
just saying that because I don't see that legislation as pertaining particularly to the debtor.
Got it.
So that would be my concern about it. Sorry.
No, that's okay.
But yeah.
Well, what about Chapter 15?
Yeah, that's a great question. So Chapter 15 is the international bankruptcy section of our bankruptcy code. It's a really big deal, right? It was only adopted in 2005 or so. And so what it does is it gives a U.S. bankruptcy judge the ability to recognize bankruptcies from abroad and likewise, right? So I had a case where a very large waste management company from Ireland was in the Irish version of bankruptcy, but they had contracts here in Massachusetts, including Martha's Vineyard. They did all the waste management work there, and the creditors were still trying to pick at their bones here in Massachusetts. So I could collaborate, literally, call and talk to, and then have hearings with this Irish judge, and I could I could recognize that bankruptcy in Massachusetts, in the United States. It would cover the entire country. There is a clause in Chapter 15 that says, unless the foreign bankruptcy involves, would be violative of the public policy of the United States. So there are some judges that say, okay, I think cannabis is legal in Canada, right?
Correct.
Yeah,
Fully legal.
it's completely legal in Canada. Our largest trading partner. So if there's a Canadian bankruptcy, then and they seek the assistance of the U.S. system, the argument would be made by a disgruntled creditor or maybe the UST. Well, Judge, you can't do this because it violates our public policy. We need to clear that up, right? We are literally at a competitive disadvantage internationally if we can't recognize companies like cannabis companies that are perfectly legal in the places where they're operating and assist them in their U.S. operations. So that's a change that I think is really going to be necessary.
Quick question,
Yeah.
and then we're out of time, but we'll turn over
Yeah.
quick questions. But what if the Canadian company has U.S. operations? How do you treat that then?
Well,
Because
they
the
want to
US
file-
operations are illegal. So Slang and Ianthus, for instance, both were filed in Canada, but they had U.S. operations.
Well, the answer is right now, I think that in all likelihood, even under Chapter 15, we wouldn't be able to administer those assets, I think,
Yeah.
Yeah, the Hacienda case that I mentioned before is out of the Ninth Circuit by a bankruptcy judge, and yeah, that is there were Canadian assets involved, and he saw it differently.
But that company itself was out of the cannabis game by the time it filed.
Correct.
So-
That's the hardest part. That's right. Yeah.
So, I mean, we could probably talk for another 2 hours because I have another bunch of questions, but we have a time schedule to keep to. Any quick questions before we release our panelists? We'll be around afterwards to answer questions.
Scott, I'd just like to mention one thing.
Sure, of course.
I painted a pretty negative picture of the M&A environment, I should say. I didn't answer this question. I think there are, green shoots in the deal market. Especially the larger MSOs have experienced an uptick in their share prices. We are seeing them being more open to including cash as consideration in transactions. And I think I think that offers hope. And there's one other thing I forgot, but
Well, I think in terms of hope, I mean, we're all used to special situations in our lifetime, and oftentimes what may be distressed can be purchased and turned around to a very successful company, and that's what part of our good restructuring turnaround team does, right, at the end of the day.
what I meant to say was, in the context of two companies coming together and creating a better picture, a better profile, and strong strategic rationale, there is capital for that. So I would say, despite the difficulties for all the reasons stated on this panel in the current market, we're seeing reasons for optimism. But
Good. It's good to end on a sign of hope, because I think there is a lot of hope for this industry. So with that, I thank you, everybody, and we'll move on to the next panel. Thank you.